Article 21 freedom of person or a personal liberty is sought to be ensured by our constitution by means of twofold guarantee, namely by providing that no person can be deprived of his liberty except according of law, Article 21, by laying down certain specific safeguard against the arbitrary arrest or the detention, Article 22, protection of life and personal liberty. Article 21 of our Constitution provides that the no person shall be deprived of his life or a personal liberty except according to the procedure established by law. This article reminds us our famous clauses of the Magna Carta that no man shall be taken or imprisoned, deceased, or outlawed, or exiled, or any way destroyed save by the law of the land. It is means that the no member of executive shall be entitled to interfere with the liberty of citizen unless he can support his action by some provision of law. In short, no man can be subjected to any physical coercion that does not admit of legal justification when therefore the state of any of its agents deprive an individual of a personal liberty. Such action can be justified only if there is a law is to support such action, that the procedure prescribed by such law have been strictly and scrupulously observed. The word law with figure in the Article 21 of the Constitution would mean a validity enacted law, and in order to be a valid law, it must be just, fair, and reasonable. Again, as the under English Constitution, personal freedom is secured by the Indian Constitution by the judicial of habeas corpus. Writ of habeas corpus. See the habeas corpus post Article 32 to 6, by mean of which an arrested person may have himself brought before the court and have to ground of imprisonment examined and remain regain his freedom if court find that there no illegal justification for this imprisonment. The court will also set imprisoned prisoner free where there is a law authorizing and deprivation of liberty of a person, but there has been no strict compliances with the condition imposed by a law. In the Supreme Court has more than once observed that those who feel called upon to deprive others a person of their personal liberty in the discharge of their conceived to be their duty must strictly scrupulously observe the form and rules of the law. But in no country can there be a absolute freedom of the individual. The principle underlying the English Constitution is the people representative assembled in Parliament who shall determine how far the right of the individual should go and how far they should be curtailed in the collective interest or for the security of the state itself. According to the exigency of this time, this was the theory adopted by the Constitution of India, is saying that the life is personal liberty are subject to the procedure established by law. The Supreme Court has, however, infused judicial review by the holding that procedure inherently means their procedure, so that the Article 21 has been turned into the safeguard against the arbitrary legislation. The history of change in view of follows until 1978 decision in Menka Gandhi case. The view which prevailed in our Supreme Court was that there was no guarantee in our Constitution against the arbitrary legislation encroaching upon the personal liberty. Hence, if a competent legislator make a law providing that a person may be deprived of a liberty in certain circumstances in a certain manner, the validity of law could not be challenged in a court of a law on the ground that the law of unreasonable, unfair, or unjust. Under the due process clause of the American Constitution, 5th and 40th Amendment, the court has assumed the power of declaring unconstitutional and any law which has deprived a person of the liberty otherwise than in accordance with the court of notion due process, reasonableness, and fairness. In England, this is not possible insomuch as courts have no power to invalidate a law made by Parliament. In the result, personal liberty is in England a liberty confined by and controlled by law, in exist only so far as it is not taken away or limited by law made by representative of people. In A.K. Gopalan versus the State of Madras, the majority of our Supreme Court propounded the view that the adopting the expression procedure established by Article 21 of our Constitution had embodied of English concept of personal liberty in preference to the American due process, even though according to the minority, the result of such interpretation was a through most immigrant important fundamental right of life and personal liberty at the mercy of legislative majority. In result of according to the majority to due process is the differences in the basic approaches, namely that although our constitution has imposed some limitation on the legislation authority, yet subject to and outside the limitation our constitution was left over parliament and the state legislature supreme in the prospective field. In the main our constitution has preferred the supremacy of the legislation to that of the judiciary. It was held that there is no safeguard for personal liberty under the our constitution beside the article 21, such as the natural law, common law. In the result where the personal liberty is taken away from the competent legislation, the person affected can have the no remedy. It is a striking feature of the development of constitutional law of India that after a long struggle, which may be said that started tangibly since 1971, the minority view of the Gopalan case has come to term in the seven judges decision in Menka case, which we have already noted. In this case, has categorically laid down the following proposition overturning the majority in Gopalan. Article 19 and 21 are not watertight compartment. On the other hand, the expression of personal liberty in Article 21 is the widest amplitude, covering a variety of rights which some have been included the Article 19 and given the additional protection. Hence, there may be some overlapping between the Article 19 and 21. In the result, a law coming under Article 21 must also satisfy the requirement of Article 19. In other words, a law made by the state which seeks deprive a person of his personal liberty must prescribe procedure for such deprivation. Such must not be arbitrary, unfair, and unreasonable. Once a test of reasonableness is important to determine of the validity of a law depriving person of a liberty. It follows that such law shall be invalid if it violated the principle of natural justice. It is provided for the impounding of a passport without giving the person affected an opportunity to be heard or to make a representation against the order of proposed. From Gopalan to Meneka. Thus, the judicial exploration completed its trek from the north to south pole. Decision Menka case is being followed the Supreme Court in subsequent cases. The Supreme Court has held that the right of life is in the Article 21 means something more than survival or an animal existence and would include the right to live with human dignity. It would include right to a minimum substance allowances during the suspension and all those aspects which go to make man's life meaningful, complete and worth living. It would thus include the right to life under Article 21 of Constitution does not include the right to die. An assisted suicide and active euthanasia are not legal. Euthanasia can be made lawful on the legislation. The Constitution bench of Supreme Court in Gyanpur case held that the both euthanasia and assisted suicide are not lawful in India. However, the Supreme Court in Aruna Ramchandran Shanbag's case noted that there is no statutory provision in our country as to legal procedure for the withdrawing life support given to a person in PVS permanent vegetative state or who is otherwise incompetent to take decision in the connection. The Supreme Court held that the passive euthanasia should be permitted in our country. Further laid down the law procedure in its connection, which is the continuity law until the Parliament makes a law subject. In March 2018, a 5 judges constitution based the Supreme Court a legal sanction passive euthanasia, permitting living will by patient on the withdrawing medical support if they slip into irreversible coma. In irreversible coma. The Supreme Court held that the risk to die with dignity in a fundamental right. Fair trial means a which buys a prejudice for the against of the accused, the witness or the cause which is being tried eliminated. If the witness is threatened or the forced to give the evidence that the also would not result in a fair trial. In the absence of a fair trial, the Supreme Court can give order to retrial even after acquittal if the acquittal is the unmerited and based on tentative evidence etc. Subject to a person to a narco analysis lie the detector BEAP test in the interlocutory manner violate the prescribed boundaries of the privacy. No victim of an offense can be compelled to undergo any of such tests, such the forcible administration would be unjustified intrusion into the mental privacy involving ill-equipped, barely literate youngsters in counter-insurgency activities wherein their lives are placed in danger could not be conceived under the rubric of livelihood. The act of using such the youngsters in the counter-insurgency activities necessary irrespect for the life of tribal youth defining the human dignity. Khap Panchayat often decree or encourage honor killing or other atrocities in an institutionalized way on boys and girls, different caste and religion who wish to get married, who have been married or interfere with the personal lives of people who is wholly illegal and has to be ruthlessly stamped out. Custodial death is perhaps one of the worst crime in the civilized society governed by the rule of law. The right of inherent in Article 21 or 21 first of the Constitution required to zealously scrupulously protected. We cannot wish away the problem. Any form of torture or cruel, inhumanity regarding treatment would fall within the inhabitation of Article 21 Constitution, whether they occur during the investigation, interrogation, or otherwise. The principal rule of law and due process are closely linked within the human rights protection. Such protection can be protected effectively when a citizen has recourse to the court of law. Failure to accord fair hearing either or the accused or the prosecution violated even the minimum standard of due process of law, since a fair hearing requires and the opportunity to preserve or process. It may be vitiated and violated by an over hasty, stage managed and tailored and partisan trial. The recent jurisprudential development with the regard of delay execution of death sentence Supreme Court communicated the death sentences onto the life imprisonment while the holding that the execution of sentence of death of the accused not within the existence of Supreme Court's supervening circumstances is violation of Article 21 of Constitution. One of the surviving circumstances sanctioned by the Supreme Court of India commutations of death sentences into the life imprisonment in the undue, inordinate and unreasonableness delay of execution of death sentences. It is attributed to the torture. The nature of delay, whether it undue or unreasonable, must be appreciated based on the fact of individual cases or no exhaust guideline can be framed in the regard. The Shatrughan Chauhan case in the Supreme Court India observed that it is will establish that the Article 21 of Constitution does not end with the pronouncement of sentences but extend to the state of execution of that sentences is already asserted. Prolonged delay execution of sentences of death has been dehumanizing effect on the accused. The delay caused by circumstances beyond the prison control and mandate commutation of death sentences. Adopting liberal interpretation of Supreme Court has read several rights of Article 21 to make life of meaningful and worth living. They may be enumerated as under. Right not be subjected to bonded labor and to be rehabilitated after release. Right to livelihood, right to decent environment, right to appropriate life insurance policy, right to good health, right to food, water, education, not a profession or special medical care, shelter, repression, right to have necessity of life, right to speedy, fair and open trial, right to open women to be treated and decency of dignity, right to privacy, right to go abroad, right to against solitary confinement, right to against bar, fetter and handcuffing, right to legal aid, right to against delay execution, right against custodial violence, right against public hanging, right to health and medical aid over, right to doctor assistance, right to social justice, economic empowerment, empowerment, right to freedom from noise pollution, right to reputation, right to family pension, right to dissent, burial or cremation, right to information, right to hearing, right to appeal from judgment or conviction. The constitutionality of unnatural offences such as the homosexuality as crime, section 377 IPC has challenged before the Delhi High Court 2001 and 2009, and Delhi High Court, after considering various constitutional provision and new development, declared the section 377 IPC insofar as the criminalizes constitutional sexual act of result or privacy violate of article 21, 14 and 15 of the Constitution. It was provided that the clarification is the judgment with hold till the Parliament chooses the amend a law effectuate recommendation of the Law Commission of India's 172 report. However, the Supreme Court of India in the Suresh Kumar Kosal in Naz Foundation reversed the Delhi High Court 2009 verdict and held that the 150-year-old Section 377 criminalizing gay sex does not suffer from the vice of unconstitutionality. However, in the light of its recent judgment, National Legal Services Authority versus Union of India recognizes the transgender community a third gender along with the male and female. The Supreme Court India agreed the reconsidered verdict of Suresh Kumar Kosal versus Naz Foundation. A constitutional bench of Supreme Court Constitutional Bench of Supreme Court Navtesh Singh Johar overruled Suresh Kumar Kosal and held that the constitutional carnal intercourse among the adult in the private space does not any way harm public decency or morality. The court held that insofar Section 377 penalties any unconsensual sexual relation between the two adults, be a homosexual man and woman or lesbian woman to woman, cannot be regarded constitutional. However, any engage in it the kind of personal activity with animal side the respect of section. If anyone engages any kind of sexual activity with animal said aspect in section 377 in Constitution and shall remain the penal offence.